Good afternoon, everyone, and welcome. My name is Marianne Monteleone, Director of Education for LIBOR, and I'd like to welcome all of you today as we celebrate National Fair Housing Month, this being April. We have a very special guest with us today. John Herrion is with us, and I'd like to formally introduce him and then turn it over to him. John Herrion is an attorney with extensive experience in disability rights. In March 2008, Mr. Herrion became Director of Disability Rights for the New York State Division of Human Rights. In this capacity, he assists with enforcement of New York State's human rights laws provisions that prohibit discrimination against persons with disabilities. Prior to working at the New York State Division of Human Rights, Mr. Herrion was counsel to the United Spinal Association for 12 years, where he represented and assisted persons with disabilities on a wide variety of issues relating to employment, housing, and access to places of public accommodation. Mr. Herrion has published articles and lectured extensively, including continuing legal education programs for attorneys on rights of persons with disabilities. He is a past chair and secretary of New York City Bar Association's Committee on Legal Issues Affecting Persons with Disabilities. Mr. Herrion holds a law degree from Pace University School of Law and a Bachelor of Arts degree from Manhattan College. It's our privilege and honor to have you here with us today, so I turn it over to you.
Thanks very much, Marianne. I very much appreciate the opportunity to be with you all today to go over some fair housing issues as related to the rights of persons with disabilities under the New York State Human Rights Law, and how the agency that I work for, the New York State Division of Human Rights, how that agency enforces the provisions of that law. Before I start to share my screen in the PowerPoint presentation, I just wanted to share, I had been a year or so ago, I was up at in Albany with the New York State Association of Realtors and was doing a similar presentation for that group. And the way they opened the program, I thought was really well done. They were recognizing realtors nationwide who had established some really good fair housing credentials in their communities, and each of the persons being recognized had a few moments to say some words, and the takeaway was that the benefits they realized through their fair housing work was community building. And building more inclusive, more diverse communities, the role they played in that, as realtors, emphasizing their fair housing obligations and building that into their business, recognized real value for them in terms of community building and inclusivity, but also in their bottom line. They had more clients, and they had a better business relationship, with the community, and enhanced their bottom line. Through engaging in fair housing, work related to their professional, part of their lives. And I think, I can certainly, and you'll hear from me today, there are compliance aspects that, are related to a law enforcement agency, the comply or else part. But I think really the better way to look at it, the more helpful way to look at it is the benefits realized through community building and inclusivity through fair housing. So I always like to share that when I'm working with groups such as yours, and appreciate your time here today. I'm going to share my screen and we can get underway. I think we'll hold questions, or I'll answer questions at the end. And let me see if I can get to my slideshow here. There we are. And the slides will also be made available. Just trying to see if I can minimize this. That's okay. We'll go from here. Sorry. There we are. Okay, let's go to this slide here. So what we'll be covering today is the New York State Human Rights Law provisions. And again, these slides will be made available that cover people with disabilities. And we will be talking about specifically coverage of realtors and the New York State Human Rights Division's enforcement of those provisions. So I'm the Disability Rights Director, as Marianne mentioned, for the New York State Division of Human Rights. Our agency is tasked with enforcing the New York State Human Rights Law. And that law prohibits discrimination in a wide variety of contexts based upon a number of protected classes. And I'll be talking about that generally a bit, but more specifically as it relates to disability. I like to share in terms of statistics that while employment cases are the number one volume-wise type of case that the agency gets, housing comes in very solidly at number two. And over 50%, I think the last time I looked, it was like 53% of all the housing discrimination complaints that are filed with our agency include allegations of discrimination based on disability, so more than half. So we get a high volume of these types of cases. The other thing I like to share, particularly with realtors or other covered entities, is a lot of times the discrimination really isn't based on any kind of animus or hatred because somebody has a disability. There is certainly a stigmatization and stereotyping that is harmful, that's associated with certain types of disabilities, right? Like mental health impairments. There's stigmatization there and stereotyping, which can be harmful and unlawful. But usually that animus that people may feel towards somebody because of the color of their skin or their religion or their sexual orientation, not typical of disability-related discrimination, although it certainly happens. But usually what it is, it's more of an ignorance of the law or assumptions that can be made, that can end up being harmful, in the long run or unlawful in the long run. So that's why I really value these types of opportunities to do some education around what the law requires, and certainly to be a resource moving forward for folks. So, if you have questions about anything that I covered today and we don't get it answered, my contact information will be included at the end. So when we're talking about, I'm just closing a window that's open here. We're talking about housing. We have a very generous definition of housing under the human rights law. Both private and public housing is included. So public housing authorities, any types of rentals, co-ops and condos are covered. Sometimes people mistakenly think they're exemptions, but there are very far and few between. So most housing is covered here in the state of New York. We cover owners, public and private and publicly assisted, any types of rentals, managing agents, co-ops and condos, real estate brokers or agents for sales of single-family homes, multifamily homes, commercial space, et cetera, and any other persons that have the right to sell, rent, or lease housing accommodations, or any agent or employee thereof. So again, it's a very generous, broad, area of coverage in terms of who is the covered entity under the law and what are their obligations. So now these are the protected classes. So you can't take any kind of adverse action or diminish the services or eliminate services for clients or potential clients based on their race or their color, national origin. You can see all of the protected classes here. Familial status is unique to New York State human rights law. There's two laws primarily that cover housing. There's the Federal Fair Housing Act, and many of the provisions that I speak of today are mirrored in that law. And then there's the New York State human rights law here in the state of New York. So there's a couple of added protected classes there. Familial status, marital status, and military status are included as being distinct for New York State human rights law protections. Some of the newer areas that have been added to the law, gender identity or expression is a protected class, lawful source of income. And this is an area we're not dedicating today's program to source of income, but it's a trending area. We're seeing a lot of complaints in this area, and I know there's a lot of coverage in the media about source of income discrimination. Prior arrest records is also a new area. Again, we're not focusing on that today. We're focusing on disability, and immigration status is probably the newest of the bunch that was added. So let's talk about the definition of disability. How are we defining somebody? What kind of impairments are uncovered? What types of disabilities are covered? So here we're talking about any kind of a physical, mental, or medical impairment that results from any number of conditions that prevents the exercise of a normal bodily function, et cetera. Really the takeaway here is it's a very generous definition of disability. Very few cases at our agency get dismissed because the person's not considered to be disabled enough to be covered by the law. So more times than not, we're talking, the focus is on whether or not the discrimination took place. Now, there are instances, and I'll cover them later, where a housing provider can ask for medical documentation to support the need for reasonable accommodation. I'll get into some of those instances later. But as I say, it's a very generous, the courts have construed our definition of disability to be a generous one. We also cover people with a record of an impairment. So you may not be manifesting, the symptoms, but because you were diagnosed with a condition at some point in time in your life, and then there is a disclosure and an adverse action taken upon that disclosure, even if you're not manifesting symptoms of a disability, if you are discriminated against because of it, you are still covered. And then even if, and we don't get many of these cases, but I do see them from time to time, if there's a perception, that you have a disability and an adverse action is taken based on that perception, you then can't say, you don't have a disability, you're not covered by the law, the case ought to be dismissed. The way the law is written here is that even a condition regarded or perceived by others can also place somebody in a protected class if an adverse action is taken based on that perception. So a distinction here, one of the takeaways from today's program is the distinction between the definition of disability and under the New York State Human Rights Law and the Federal Fair Housing Act. So the Federal Fair Housing Act defines disability as a substantial limitation of a major life activity. We don't see that phrasing right on this slide here. There's no requirement that the impairment be substantial. There's no requirement that it be a major life activity. So again, cases that are brought under the New York State Human Rights Law standard are not scrutinized, at that threshold in terms of determining who's covered as a person with a disability. So we have explicit coverage of realtors under the New York State Human Rights Law. And it's unlawful for real estate professionals. These are some of the prohibited unlawful conduct under our law. So you can't discriminate in the negotiation or sale of a rental, including stating that a property is not available when it is. You can't offer or negotiate discriminatory terms or conditions in the privilege or sale of a lease. That's unlawful conduct. Also, the use of any application or advertisements that can directly or indirectly include any limitation or discrimination based on a protected class, including disability, is unlawful. And there's direct liability here. Realtors, we take these cases seriously. Realtors are the gateway to housing. So if discrimination is occurring, at that level, it really has a terrible impact upon people who are qualified for housing and are being treated in a way because of the color of their skin or because of a disability, in a way that's less than. So there's direct liability under the state human rights law for discriminatory actions, whether or not they're requested by the client. So again, very important concepts to be aware of today. Steering, also unlawful. And as many of you probably know, steering would include guiding or making recommendations to prospective buyers or renters towards or away particular neighborhoods or locations, based again on membership in a protected class. That can be considered a violation of the New York State Human Rights Law. So we mentioned this earlier, liability includes brokers, salespersons, their employees or agents thereof. And again, these cases can result in, damages, financial damages, compensation for any type of financial or emotional harm. Punitive damages can be assessed, where the matter is particularly egregious, including civil fines. And then, of course, it's much, much better to be doing this training now, right? To be able to, not have this be part of a settlement agreement or some part of a final order, against a realtor or an agency that you work with. Talking about this training now, I think really has value and benefit. But these are some of the remedies, that can be awarded and ordered under the New York State Human Rights Law. Also want to share with you that we have a partnership with the New York State Department of State. So not included in our remedies would be the, taking the license away from a realtor. The New York State Department of State has that authority, right? They license real estate professionals in the state of New York. So terminating a license or removing a license from an individual is something they can do if that realtor is involved in violating fair housing requirements. And so if Department of State, if they get a complaint against a realtor related to these issues, they can refer that case to us, where we can, if we do have a finding against the realtor, we can issue these types of penalties. And New York State Department of State also has as I said earlier, has the authority to remove that license. So again, it's a partnership, that we value in terms of trying to root out, the bad actors who are involved in fair housing violations. When we're talking about, so this applies to the housing providers, right? So we talked about specific realtor prohibitions, but now your clients are also, this is something you want to make sure your clients are aware of. And that is not refusing to sell or rent housing accommodations on account of disability, and also the terms and conditions, of the rental or the ownership. We sometimes get, kind of, I call them heat and hot water cases or repair cases, where somebody may be alleging that, they're being denied heat or hot water or timely repairs. And, we investigate those cases. Our investigators can gather comparative data. And so if they find, which means they can talk to other residents or tenants that are at the premises. And typically they find one of two things. One is that, well, nobody's getting heat or hot water. This is just a bad landlord for everyone. There's no discrimination going on. Or alternatively, it's the family that maybe has a child who's living with autism or living with schizophrenia, and they're being targeted. The terms or conditions of their lease or their ownership of the premises is being diminished because the housing provider is looking to get them out. Make the conditions in such a way that they would leave. And we do get those cases from time to time. So again, the takeaway here is it doesn't have to raise itself to the level of an eviction or a denial of a housing opportunity. It can be the terms or conditions of the rental or the ownership of the home. Also can't circulate applications or forms or do advertising in any way. Making any kind of inquiry as to disability, list any medications you're taking, list any types of hospitalizations or family history of medical or mental illness. All those kind of inquiries are prohibited under the state human rights law. If you have an application for housing, they shouldn't be there. And what we have found at the agency is when they are there, they typically lead to a vetting, of somebody because they have a disability. Once they list medications, et cetera, it can be used to violate fair housing law requirements. So those types of inquiries are unlawful under the state human rights law. So this is a new change to the law that has to do with advertising. So previously, owner-occupied two-family dwellings were completely exempt from the state human rights law. So that would be a question, right? So if a complaint gets filed and it's indicated that it's a two-family dwelling, is it owner-occupied? There was an exemption there still is an exemption carved out for that until and unless the owner advertises in an unlawful way. So if there's some type of advertisement that includes directly or indirectly some form of discrimination, all of the human rights law applies. So it's not just the advertising prohibition that's extended there. It's all of the obligations that the New York State human rights law requires. And the prohibitions against discrimination that are there are now, like, that avenue is now opened up if advertising is done in a way that's unlawful. So that's somewhat of a new change in our law. As we say here, not only would the owner be liable under the advertising provisions, but now the New York State human rights law would apply in full force to the property whenever that occurs. So getting back a little bit more to the disability components of our law. So, as mentioned, you can't deny, you can't evict, on account of disability, and that is similar across the board, right? So any protected class, right? You can't evict somebody because they're African American, or evict somebody because of their sexual orientation or their religion or membership in another protected class. When it comes to disability, there is a added layer of obligation that requires housing providers and realtors to perhaps do business in a different way in order to accommodate somebody's disability so that they can access services, so that they can live, use, and enjoy a home. So it's not just denying or diminishing services. There's this added affirmative obligation to reasonably accommodate people with disabilities. And I'll take us through that a little bit. So we're talking about reasonable modifications. We're typically talking about structural type modifications. So installing a ramp, installing a handrail, maybe widening a doorway, doing something structural to the home. And kind of starting out here. So if you have a client who uses a wheelchair, stay away from assumptions, right? Stay away from, well, I guess I can't show this client any homes that have steps or that may have steps inside. You don't want to lessen the types of housing you'd be sharing with that person or show it in any way, shape, or form different than from some other client who doesn't use a wheelchair, because you don't know what the capacity of that individual is and what they may do or may not do. And the same thing goes for rentals. So this is good information to have, to know that the owner of a rental or the provider of housing has obligations to structurally change, and also to change rules and policies. And I'll get into that in a moment or two. Change the layout of the home, so long as where it's reasonable. The idea is that, the language in the statute is reasonable modifications to make it usable for people with disabilities. So taking you through this section of the law here, it says housing providers must permit at the expense of a person with disabilities for reasonable modifications of existing premises occupied or to be occupied by said person if the modifications are necessary for full enjoyment of the premises. So let's take you through this a little bit more. So housing providers have to permit. So in order for there to be permission, there needs to be a request, right? So a request for some type of work to be done to make the unit accessible at the expense of a person with a disability. So if the modification is being, a lot of times we get asked, well, who pays for this work? And we answer that question with another question. We say, well, where on the premises is the work necessary? Is it the interior of the person's unit? Yes, it is. It's the kitchen or the bathroom. It's the interior premises. Then the cost is to be borne by the resident, the person who occupies the unit. Landlord or housing provider cannot refuse permission, but is not required under the law to pay for those modifications. That is on the tenant's dime. So we also are talking about reasonable modifications of existing premises, occupied or to be occupied. We sometimes get respondents who will say that their building is grandfathered in. It wasn't, it was built before the law was passed, and that doesn't hold any water, right? So we're talking about existing premises here. So, the extent of the investigation is, does your premises exist? And if it does, the investigation on that is over. There's no grandfathering. So we're talking about existing premises occupied or to be occupied. So somebody's moving in, right? Maybe it's a co-op and they've jumped kind of through all the hoops, and they're meeting maybe with the board and going over the home rules, and maybe they're going to need some type of structural modification to be done, and they share that at that point in time. The board can't then say, oh, you don't reside here, you don't occupy here, you don't have any rights to be occupied. You can see that in the phrasing here. So again, your clients who are looking for housing and may need some of these modifications, so long as they're otherwise qualified to purchase the housing, they're covered by the law here in terms of doing reasonable modifications. And again, if the modification is necessary for full enjoyment of the premises, this is the language in the statute, full enjoyment of the premises. And we sometimes see cases at the agency where somebody will ask for a ramp to be installed so they can get in and out of their apartment building. And the housing provider will say, we have a ramp, and we'll send investigators out to do site visits when we can. And they'll find, yes, there is a ramp there, but it's the back of the building, and it's used to take the garbage in and out, and it goes by the boiler and, through the basement, and it does get you to the elevator, but that's not really full enjoyment of the premises. Full enjoyment means going in and out the front door just as everybody else is. And so long as it's reasonable to do that work, that's what's going to be compelled. And again, I keep using the word reasonable. Essentially what we're doing is we're balancing what is the cost of the modification. If it's something, and I know I talked about the cost being borne by the interior of the unit, but the human rights law was amended in 2010 to require housing providers to pay for reasonable modifications in common areas. So if we're talking about that front entrance, to an apartment building that's commonly used by folks to get in and out, making that area accessible, the cost is borne by the housing provider. And so long as it's reasonable. So again, we are balancing what is the cost of this modification versus what are the resources of this particular housing provider. So it's on a case-by-case basis to meet that cost. So again, that question, who pays, is met by the question, well, where are we talking about the modification being done? Interior is going to be, and again, this is something to share with your clients too, right? I'm going to need to do some work to the kitchen. Well, you may be expected to pay for that work. The landlord can't refuse it, but you may be, you should expect to pay for it. We talked about some of these examples: widening doorways, making adjustments to kitchens, et cetera. Installation of grab bars are typical examples. We talked about the amendment related to common areas. So the other area that we see this need for reasonable accommodations is not necessarily structural, but policies and rules, right? So having a no pet policy is perfectly lawful. There's nothing unlawful about that. Or having a pet policy with certain types of limitations as to pets is perfectly lawful. But under the human rights law, people with disabilities who have a disability related need for a service animal or assistance animal, emotional support animal, can ask the landlord to waive that, or the housing provider to waive that no pet policy for someone, so that they can reside with their service animal or emotional support animal. And I'm going to get into more in the way of detail on that in a moment. Another form of accommodation to, a policy or procedure would be if somebody needs a parking space, right? And the policy is, maybe first come, first serve, or all of our spots are currently taken. It may mean that there's an exception made not to move somebody out of a parking space if they're all taken, but to put that person with a disability on the top of the waiting list for the spot that is needed by that person, so that, if they have a mobility impairment, that they can park close to their unit. We get, sometimes the responses on these that we get that are somewhat typical is a landlord will say, we already have accessible parking, but it's first come, first serve, or, we can't designate a spot. All of those policies, right, need to be modified. That's the whole idea of reasonable accommodation, to modify an existing policy to allow somebody with a disability to use and enjoy the home. So modifying that policy, designating a parking space for somebody who has a disability related need for that parking space so that they can be closer to their unit is a form of reasonable accommodation that the human rights law compels. There's a notice requirement that's fairly new, 2 years old at this point, that was passed, that requires notice to be provided by housing providers to tenants and prospective tenants of their right to request reasonable accommodation. So, a lot of times when we work with, people in the disability community, they'll say a lot of people don't know that they have a right to ask for these things. And the legislature in New York State passed a law stating that housing providers need to put both tenants and prospective tenants on notice that they have the right to request this. I have been told, and I include this last bullet here on the bottom of the slide, that the delivery requirement for this notice conforms to the anti-discrimination disclosure form required by Department of State, otherwise known as HADDFN. I was advised of that by the real estate industry. So if people have questions about that, or that's inaccurate, I'd like to know when I'm working with covered entities, and I'm told that's appropriate. Just want to be able to confirm that, and we can save that for later. Wanted to talk a little bit about new construction. So any type of new construction that was built, so multifamily would be considered 3 or more units. A little bit different from the Federal Fair Housing Act, which requires 4 or more units. So multifamily are defined as 3 or more families living independently of each other on the residence. And anything built on or after March 13 of 1991 that fits that definition has some design and construction requirements. So public use and common use portions need to be readily accessible and usable for persons with disabilities. Doors have to be designed to allow passage in and out of the premises sufficiently wide enough to allow people who use wheelchairs. And there needs to be an accessible route, into and through the dwelling. And that typically means from the parking area in and through the in and through into the ground floor of the units. So again, it's the availability of accessible housing for people with disabilities is really limited. So, when new construction goes up, if it doesn't meet these standards, it really impacts, significantly on people with disabilities in our communities, and an inability to move into some of these new constructions. So, we take these cases seriously. We try to be on the lookout for them. And, hopefully, architects, designers, builders are mindful of their obligations that are more spelled out under the building code than in the New York State human rights law when it gets to the specifics of how wide a door needs to be, what the slope of a ramp needs to be. That's kind of a whole other program in terms of the technical requirements of these laws. But there are some really good organizations out there. I can connect you with some of them that do some of those technical building code compliance issues. That's helpful to have as well. So requirements here, the interior light switches, electrical outlets, et cetera. Environmental controls have to be in accessible locations. And then for new construction, reinforcement in the bathroom walls to allow for later installation of grab bars is also contemplated. So I want to talk here a little bit about guide, hearing, and service dogs and emotional support animals. So we have an explicit provision in our law that speaks to guide, hearing, and service dogs, and the word is dog, that are professionally trained. So typically guide dogs fit this, this requirement. Some hearing dogs and service dogs do as well. And when we have that kind of a case where somebody has been told they can't have a professionally trained guide, hearing, or service dog with them, there is explicit obligations under the human rights law that require that the dog goes, that type of a dog, professionally trained dog, goes where the person goes. So we have explicit provisions that address those types of dogs. In housing, it's a much more broader universe of assistance animals that are allowed within reason, right? Because this is all within the construct of reasonable accommodation, okay? Which is here, that waiving the no pet policy. So we are operating in the universe of reasonability. So, and we do evaluate these requests because invariably, you get the story of like the emotional support peacock or the, one of those types of things. And we do have some scrutiny that we engage in with those types of cases. So emotional support animals. So the issue here is there is confusion sometimes between housing and places that are open to the public. So places that are open to the public, like, your Walmart, your Target stores, restaurants, et cetera, they have a separate set of obligations that I'm not going to confuse you with today, but I'm going to speak specifically to the obligations in housing because that's what we're focused on. So in housing, emotional support animals and assistance animals that are not professionally trained, we go into our reasonable accommodation analysis. So that analysis usually includes a couple of questions. One is, do we have a person with a disability? And remember, we have a very broad definition there. And two, probably more focus here, more scrutiny here, is there a disability-related need for the animal? So if the answer must be yes to both those questions, right? We need to have somebody with a disability, and we need to have somebody with a disability-related need, not just somebody with a disability who would like to have a cat or a dog, but that there's a disability-related need for that accommodation. And the landlord is entitled to medical documentation to support both of those items. Places that are open to the public are not. They cannot ask for that, but landlords can, housing providers can. So, we don't see many of these cases with somebody who's blind who needs a guide dog. That's pretty readily apparent. But we do see them often in emotional support animal cases, right? And in those instances, if the individual provides a letter from a treating medical healthcare professional, that they have the disability and there's a disability-related need for the animal, that typically suffices. Now, we do scrutinize these, and I know people feel like sometimes they're getting gamed, or you can go online and pay a fee and get a certificate. We will scrutinize those, and if that indeed is the case, the answer becomes no to one or both of our questions, right? Is there a disability, or is there a disability-related need for the animal? But the landlord is entitled to the medical documentation to support both of those items and can ask for that. And now when we get into, remember I mentioned earlier, landlords are allowed to have pet policies, that may have breeder size limitations, have to waive those, right? Again, we're talking about accommodations. We're talking about modifying a policy. So can you have a policy that prohibits pets? Can you have yes. Can you have a policy that sets limitations for pets? Yes. Here's the takeaway. Emotional support animals, assistance animals, and service animals are not pets. They have to be treated differently. They're accommodations for people with disabilities. So in that regard, somebody who needs a dog that maybe is on the breed restriction, or needs a size animal that is above the weight restriction, or needs an animal in general, and there's a no pet policy, waiving or modifying those policies to ensure that the person with a disability can get that particular animal to accommodate their particular disability, is something that the human rights law contemplates as a reasonable accommodation. The other thing is fees, right? You can have fees for pets. Again, what is the takeaway? Emotional support animals, service animals are not pets. Now, if you have a emotional support animal, even if they've been professionally trained, and that it usually doesn't result in this, who become a nuisance, who engage in behavior that's considered a nuisance by other neighbors or others living there, a landlord can take whatever lawful action is necessary to address that. But landlords and housing providers can't speculate, that because there is an emotional support animal there, that it's going to create a nuisance or create a problem. Speculation is not allowed. But if there is indeed a problem, again, even if it's an emotional support animal or a service animal of some sort, even if it's been trained, landlord can take whatever lawful action is necessary to remedy that. We sometimes get some confusion about what can a landlord ask for. So as I said, landlords can ask, or housing providers can ask, for medical documentation to support the need for the emotional support animal or the assistance animal. Asking for certifications, like I want to see the certification that this is a recognized, credible emotional support animal, is not something that our agency is looking for, nor is required. It's not, you don't, although there are agencies out there that may nefariously charge fees for this type of a thing, it's not a training that needs to be done to make the animal a recognized emotional support animal. It's the relationship between the person and the animal, that improves the quality of their life. And there's a lot of medical literature out there to support this. And so again, you may have a professionally trained dog, which is great. But landlords cannot say, I will only grant you this if you provide me with the license for the emotional support animal that's been trained. That training component is not necessary. And we're talking about emotional support because, again, it's not any kind of training. It's really the relationship between the individual and the animal that improves the quality of their life. So getting away from substance and going to form. So how does the process work? So it's very easy to file a complaint with our agency. The complaint forms are available online. Once a complaint gets filed, it gets assigned to an investigator. That investigator is going to gather all the information they need to make a determination of either probable cause or no probable cause. Probable cause means there's enough there to credit the allegations of the complaint. And doesn't mean complainant has won, but it means there's enough there to credit the allegations, and that the case will get assigned to our prosecutions unit. We have a unit that's staffed with attorneys who prosecute these cases, and the case will go before an administrative law judge for a hearing. The administrative law judge, after the hearing, can issue a recommended order, which our commissioner then is the final arbiter on. Cases can settle at any point in time, and often do during the course of the process. They often settle after a probable cause determination is issued for purposes of resolving the matter. But if the case does go to a full hearing, that's how the process unfolds. Either party in housing cases can elect the cases out of the Division of Human Rights and into state court. Our prosecuting attorneys will follow the case into state Supreme Court. And after the public hearing, we have a final order at the division that the commissioner issues. If the commissioner finds that discrimination has occurred, these are the remedies here. It could mean make the housing available, make any kind of reasonable accommodations or modifications that we talked about in order for somebody with a disability to use and enjoy their home. It could be compensation, so financial compensation for any type of mental anguish that was experienced or endured because of the discrimination is also a remedy that we can provide. Any type of compensation for out-of-pocket expenses, compensable damages are there. Punitive damages in housing cases, civil fines. These are cases where the findings are particularly egregious. The discrimination was particularly egregious. Again, we covered this earlier, requiring the housing provider and staff to attend anti-discrimination training, and of course, any types of orders to cease the discriminatory actions. Attorney's fees are also available. So complainants, can recover attorney's fees if they prevail. So here's my contact information. We have the general information for the Division of Human Rights, and also my direct contact information is here as well. Again, I'm happy to be a resource for folks. We've, as I was sharing with Marianne earlier, we've really enjoyed our relationship with realtor associations around the state of New York. As I said earlier, I think there's real benefit and value in doing this educational piece around disability, because oftentimes the cases we get, is that there's just ignorance of the law, which is never a defense, right? Gaining this information and understanding, and again, getting back to my first point, with the idea of doing community building being realized through fair housing work, I think is really, one of the premier benefits that can be realized, through the work that you do with your clients, to ensure that fair housing is being realized here in the state of New York. So thanks for the opportunity to be with you all. I'm happy to answer any questions. I think maybe I see one in the chat and one in the Q&A. So let me see if I can get those. And I'm seeing here from Patrick. Thank you, Patrick. The reasonable accommodation and modification notice must be provided to all prospective tenants at first substantive contact, which is the same standard for New York State housing and anti-discrimination disclosure form. Thank you, Patrick, for that bit of information added. And Q&A. Hi, John, it's Marlene Patty. I know Marlene. Is there any incentives from the government, federal, state, or local, for monetary support for reasonable accommodations for persons with disabilities, or for builders to use as incentives to make housing accessible to begin with? So there are some forms of revenue. I know, like I don't know if it's still the case, but I don't think it would have changed, but U.S. Department of Veterans Affairs. So if you're a veteran with a service-connected disability and you need some type of an accommodation done or modification done at your home to make it accessible, there's a funding source for that. I believe there are certain not-for-profits. At one point in time, UCP, United Cerebral Palsy Foundation, had revenue streams available for people who needed financial assistance for making their homes accessible. So it may be a little bit of homework, on your end, right? Because that would be a typical conversation with a client, right? A client says, I'm going to need to do some work to the house or the home, the apartment, to make it accessible. Who pays? Well, now you know what the answer is, right? You answer that with another question. Well, where are we talking about? Oh, we're talking about the kitchen or the bathroom. Okay, well, it's going to be your obligation to pay for it. Maybe taking a look, maybe depending on the nature of the disability, maybe looking locally, are there any local revenue streams? I know at one point Fair Housing Justice Center had money for, I think it was architectural work, like any type of design that architects were going to do to make homes accessible. But, I don't want to put anybody on the hook and say they're available to pay for this, when indeed, if they're not. But, that was some anecdotal type information I had based upon, partnerships and work we've done in the past. But I think it's worth doing homework on that. And I'm not aware of any state, local government incentives other than the one that I mentioned from the VA to make housing more accessible. Let's see, anything else here? I don't think so. So we still have a little bit of time, I think. Are there any people can unmute, or I don't know how you want to handle it on LIBOR's end?
I think we look like we're good. We can wrap up a little early here if no one else has any questions. It seems like we've answered everything. If anyone has anything else they want to ask, we can put it in the chat. Oh, it looks like we have something in the chat right here from Andrea.
Let's see. Do you know the name? Oh, so they're asking for the name of the form. So, so Andrea, I'm not sure if it's the notice form you're relating to. There's no official form that's recognized by Division of Human Rights in terms of asking for a reasonable accommodation. That I think it's smart for housing providers to have some forms involved, just to memorialize it and to let people know what the process is like. So I'm going to answer that question a little bit of a different way. While there's no obligation to have a form, I think it's helpful, but it's also, once that request has been made, orally or otherwise, that puts all of these requirements into play. But I think memorializing them is important and smart, like as a best practice for housing providers. But if the question is more so to what Patrick Fife mentioned on the New York State Housing and Anti-Discrimination Disclosure Form, I would invite Patrick maybe to chime in if he's still here, or maybe LIBOR could follow up on that if it's the name of the form that's being asked for, as I fumble with this answer.
Let's see. Seems like Patrick. Yeah, so I can grab a link for that on the Documents on Demand page.
Thanks, Steve.
I think we have the ability to let them talk in this. Otherwise, I would have them.
Oh, okay.
But
got it.
here, let me grab a link to that, and we can.
Okay, so Marlene is asking of complaints related to disability. The most common complaint is a failure to reasonably accommodate. That's where we see the most types of complaints at the agency.
All right, great. So I think that covers it. If anyone has any other questions they want to throw in before we wrap up here. Seems like we covered them all. Oh wait, hold on, sorry, we got one more in in the chat from Alicia.
I see it. What if the tenant can only afford to replace a granite kitchen counter with Formica? So I'm not, is this related, would this be related to disability? I mean, if you need to lower a kitchen counter or raise it for somebody who uses a wheelchair, can only afford. So yeah, I mean, if the landlord is saying like, you can only use this type of construction material or what have you, and is denying the accommodation, I think the tenant may have a colorable claim under our law, right? Because the whole idea behind reasonable accommodation is to modify a rule or policy that you have in place so that somebody can use and enjoy their home. So if the policy is that we can only replace granite counters with Formica counters, we may have to modify that policy for somebody with a disability who may need, it does not have to be similar quality. No, there's nothing in the human rights law that compels the type of quality that needs to be used. It needs to be done to make it usable for the person with a disability. So I don't think a housing provider would be able to rely on a policy that says we can only use this type, you can only use this type of materials in your work. They'd have to have a really good reason for that in order to kind of demonstrate maybe an undue burden argument to avoid the reasonability of the request. But I would say that a landlord who is going to stick to, you can only use this type of material if you're doing the modification work, and then it's not affordable by the tenant, they could be running afoul of the human rights law if they then deny the accommodation there.
Here we have one more question in the Q&A here. I can read it over to you. Jennifer's asking, what happens when the tenant has a service animal and a pet and the landlord is trying to evict?
So what is the reason for the eviction? If it's for the service animal, right? We don't want you here with a service animal or an animal of any kind that could be unlawful under the human rights law, right? You can't evict somebody with a disability who has a disability related need for the service animal. If there's also a pet that is there causing problems, not the service animal, or there's a no pet policy and this is not a service animal, then the landlord is not doing anything unlawful there under the state human rights law. These laws apply to the service animal as related to the person who's residing there with the disability.
All right, I think we covered all of them. That was great. Thanks so much for answering all these questions here at the end. I'll let Marianne wrap us up here.
Yeah, I want to thank you for being with us and sharing all that information. As I said in the beginning, I'll be calling on you to do a bit more with us.
Yeah, happy to do so, Marianne. Thanks for the opportunity. Good to be with everybody today.
Great. Thank you all. Have a great day.
Bye now.